Good morning, Ms. Kavanaugh.
May it please the Court, Lisa Kavanaugh on behalf of Angel Ortiz. This appeal raises two legal issues. First and foremost, whether Article 14, unlike the Fourth Amendment, requires suppression of evidence seized pursuant to a warrant whenever an affiant intentionally deceives the magistrate.
Okay, from where do you get the predicate fact that there's been an intentional omission to deceive?
The judge did not make a finding one way or the other,
Okay.
because under the law as it existed at the time this case was litigated, she was not required to. And I think Judge Kottmeyer made fairly clear that she was troubled by the omissions in this case, but then went on in her decision to make clear that she did not believe she was required to determine whether those omissions were intentional or merely reckless, because on balance there was still sufficient evidence to establish probable cause.
Right, so where do you get that premise that, or you're just arguing that we should adopt a new rule?
What I'm suggesting is that if this Court were to adopt a new rule, this case would need to be remanded to Judge Kottmeyer for a finding about whether or not the affiant in this case acted with an intent to deceive or not. And I do submit that there was evidence from which she could have inferred an intent to deceive, that was before her at the time of the hearing, and therefore that this issue is clearly properly before this
Well,
Court.
would you agree that if there were to be such a rule, that part of it perhaps should be that the false or deceptive or whatever you want to call the evidence was given knowingly, was made knowingly, and for the purpose of obtaining the warrant and influence the decision? What I'm doing is I'm trying to adapt the standard we've done for grand jury testimony from Mayfield.
I would agree that there needs to be some materiality, and the Commonwealth suggests, I think, somewhat unfairly, that you know, certainly there are all sorts of omissions that would not fall into that category.
Is there a difference between a misstatement that's inaccurate and a withholding of information that might impact on the magistrate's decision?
I think that under Franks, that both are treated the same, that there is a line of cases that Franks itself dealt with, and the Massachusetts counterpart initially was dealing with deliberate, or with misstatements, either deliberate or reckless, but that subsequent case law has acknowledged that omissions that are made intentionally or recklessly can have the same effect and should have the same effect. And
such that a Franks hearing could be based on omissions, is what you're saying?
That's correct.
And you've got cases to that
And
effect?
the cases in Massachusetts are numerous that acknowledge that as a basis for relief under Franks, for getting a hearing initially.
You say it can have the same effect. So in other words, you're still agreeing that it would have to be material.
Yes.
But in this case, the judge said that I think she said that even without it, there was probable cause.
I think the question of whether something is material to probable cause and whether it eviscerates probable cause that's a different standard. That what I'm suggesting is that the omission does need to be material to probable cause, but it need not be fatal to probable cause. In other words, by putting in that information and looking at the full equation of what should have been before the magistrate, that omitted piece of information need not be the straw that broke the camel's back, as it were.
I'm sorry, I don't have much of a voice, but what is the Corvo is a case in which there were omissions and no hearing was required. What's a case in which a Franks hearing was held on omissions, a Massachusetts case?
I believe, sorry, if I could just get my omissions cases before me. I believe that, well, first of all, I think that that Corvo itself was a case in which the reason that the hearing wasn't held, or that it was determined that the defendant wasn't entitled as of right to a hearing, was because the differences in the court's estimation were of so little significance that they could not make out their initial burden of establishing that the omissions or the misstatements were significant and were pertinent to probable cause.
And the court read the entire affidavit. What would be wrong with that? Seeing the value of the omissions in relation to the entire affidavit. What would be wrong with that as a test?
I'm sorry, I missed it.
Oh,
I hate to make you repeat it.
Sorry. maybe I should just not. But here's the question. Corvo appears to say, when you look at the whole affidavit, there's nothing about the color of the car or the size of the grill that is material to the finding of probable cause or that would be misleading on the finding of probable cause, so we don't need to go any farther. Well, and I'm asking you, what do you think of that as a test when you're talking about omissions versus misstatements?
I think that whether you're dealing with misstatements or omissions, that the initial burden on the defendant is to show that there is materiality to probable cause, as opposed to that it would be fatal. And I think that that the defendant here met that burden by establishing that the omissions in this case were material, if not fatal, to probable cause. And I say that because here what happened is it's not simply, I think we would be in a different situation if the affiant here had simply not mentioned identification evidence at all. But having chosen to do so, having chosen to put in a piece of that evidence, that reflects the affiant's determination that that was essential to his showing of probable cause. In other words, the affiant himself made a determination, I want to include this information because I think it's essential to my showing of probable cause.
Don't you think that if the affiant didn't include any information about identification, you'd be here with the same argument, essentially?
I think I would have a much harder burden, because the reason that we can infer an intent to deceive here is because of the fact, I think it's actually quite similar to the Odell situation, where part of the defendant's statement is put before the grand jury, but conveniently all the exculpatory portions are left out.
Let me ask you this. This is a search warrant for an apartment that was both of their apartment. So you would not deny that there's definitely plenty of information and probable cause for that apartment because it's where Perez also lives, right?
Yes, and
So
I don't contend here that this was decisive on the issue of probable cause, but I do believe that it was material to probable cause. I think there's a difference.
How could that be if you've got a joint apartment and you've got evidence about Perez?
Because the affiant was essentially asserting to the magistrate the identification evidence in this case connecting the defendant and his brother to this crime is ironclad. And in fact, the evidence was not ironclad. He chose to include portions of it, and I think, therefore, put that information before the magistrate in a way that was inherently misleading and that was inherently, could well have shaped the way that the magistrate viewed other facts.
But if we change the law, I mean, right now, it seems to me the way the law is, the affiant has to present probable cause. He doesn't present things to detract from probable cause.
Well, the affiant has a duty to present the evidence in a manner that is not deceptive of the magistrate. Okay. And I think in this case, the evidence of deception, and I'm not suggesting that the court made a finding of deception, but the evidence from which the court could infer an intent to deceive here derives from the fact that the affiant gave a deliberately less than complete and one-sided presentation of the identification evidence.
Because he's trying to establish probable cause. He's not trying to defend the case.
However, having chosen to
can't establish probable cause. If you've got one witness who says the person is there, and 10 witnesses who says the person isn't there, the question is there probable cause, right? And you're saying if the affiant simply puts one person who's there, Justice Cowan would suggest, you don't need the other 10.
And what I would suggest is that here there is a difference between simply making the determination, the affiant making the determination, I don't need any of this identification evidence because there's so much other evidence of probable cause. I'm not going to get into that issue with the judge. And what occurred here, which was his choice to put in a partial picture, an imperfect picture, and a misleading picture of the state of the identification evidence. And I think that there is a case that I cite in my brief. I apologize for not having it at the tip of my tongue, but one of the cases in another jurisdiction which talks about the fact that, I believe it's the Cook case out of California, which talks about the fact that that this could well, had the magistrate known at the time that the magistrate was assessing probable cause, that the affiant had chosen to put in this deceptive picture of the identification evidence, that might have caused the magistrate to question other aspects of the evidence that had been presented. In other words, it has a bearing on the affiant, the magistrate's assessment of the affiant's credibility.
Let me go back to a point that Justice Cowan had made, or a suggestion that there's a possibility that we might want to use the jurisprudence in a similar area affecting grand juries. And one of those is that if there is an omission of material that would have affected the credibility of a key Commonwealth witness at the grand jury proceedings, if there's an omission of that affecting the credibility. And here, it seems to me the similarity is what they're omitting is some key information that affects the credibility of the identification witnesses. And if that was done with the intent to get a search warrant, using the same analysis with the intent to get an indictment, it works well in your model.
Yes, I believe it does, and I think, in fact, that the Odell analysis works even further than that, which is to say, not only would this rule parallel the requirement under Odell that dismissal of an indictment is required where the grand jury presentation distorts the meaning of the evidence on a key point.
Distorts the meaning to the effect that what, the grand jury would have found otherwise?
Well, I think that it's not, I don't think it's required that the grand jury would necessarily have found otherwise, because I think there's no way to know.
There's got to be prejudice. There's got to be some significant prejudice. What's the prejudice?
That it distorts the meaning of important evidence.
That's it? That's what the Odell, it just distorts the meaning of important evidence? That's enough under Odell?
I believe so. Odell also goes further and acknowledges that where a prosecutor's conduct before the grand jury is shown to be willful and deceptive, that an indictment may be dismissed with prejudice.
Okay, but in Odell, the consequence is simply that the Commonwealth has to go back to the grand jury and get a new indictment. They can do a do-over. If you suppress a search, there's no do-over. You lose that evidence. It's a much more severe sanction than in Odell.
And I think that the problem is, well, to begin with, the sanction is always more severe in the context of Fourth Amendment violations and Article 14 violations because the concern, I mean, in every situation where a defendant wins a motion to suppress, evidence is suppressed, and the case may well go away.
With Odell, it's not suppressed. It merely means the Commonwealth has to go back to the grand jury and offer evidence without the taint that they offered the first time.
But in Odell, and in the grand jury presentation context, we're not talking about a violation of the defendant's constitutional rights. Here we're talking about obtaining a warrant to violate the defendant's privacy rights.
Is there any state case which has done this fatal in fact based on a false statement that was not perjurious as opposed to an omission? The ones that you cited appear all to involve perjury.
I do believe that the cases that I cite to in other jurisdictions have addressed, have been concerned with affirmative misstatements as opposed to omissions.
You want us basically to be the first state court which will extend the perjury exception to Franks to be an obstruction of justice exception to Franks.
Well, I think that this court has already indicated in $992 that strong skepticism about the adequacy of Franks to deter deliberate police misconduct.
Okay, but
I think this court should
is there a difference in terms? I mean, I understand the theory presented that if an affiant is prepared to lie to the judge, that maybe that may taint the other information and may put in question the other information. But do we have that same inference if the judge finds that the individual intentionally omitted information but did not make any perjurious statement?
I think it's just as much of a lie to mislead the magistrate by leaving out critical aspects of evidence as it is to affirmatively misstate.
Surely it's not a prosecutable law. It's not perjury. I mean, that's a very different step of misconduct.
But I don't think that's required under either Franks or this.
But you're asking for an extreme remedy. You want an extreme remedy for something that doesn't essentially affect the outcome.
I'm asking for the only effective remedy to deter police misconduct in this context. I think there is no other remedy that will adequately assure that the warrant application process has integrity. If this court doesn't,
but no other court has adopted the remedy you're asking somehow. But it's not possible that there's a remedy without without this remedy, this extreme remedy you're asking for?
I think that this court has already indicated its willingness to treat both omissions and misstatements exactly the same in the context of the traditional Fourth Amendment analysis, which is whether you're dealing with an omission or a misstatement, the analysis is the same.
But you take that just from $992?
No, I think that there are a number of cases that acknowledge the existence of a remedy for omissions that are, and I apologize, I don't have them all at the tip of my tongue, but my brief identifies a number of cases in which this court and the appeals court have both recognized that Frank's remedy is available for either omissions or misstatements.
But if you want us to authorize this drastic remedy for omissions, it's really a slippery slope, isn't it? Because there are so many omissions, and there could be, I mean, you go all down the list. There are all sorts of omissions, then you get to omissions from investigations and on and on and on.
I think the way that the slippery slope, the reason that there is no slippery slope here is because it would be the extreme case. I think this is one of them, but I think it is the extreme case where a defendant is in a position to establish not only that an omission occurred and that it was material, but also that it was intended to deceive. I think what makes the facts of this case uniquely positioned to make the case here is the fact that the affiant included a portion of the identification evidence and left out all of the exculpatory pieces of evidence about the identification procedure. That is what, in this case, gives rise to an inference of intent, and I think it's going to be exceptionally difficult for defendants to establish an intent to deceive as opposed to mere recklessness or as opposed to negligence or,
So what
or
you're
even
saying
a valid...
is whenever identification is mentioned, the police should, in the affidavit, indicate all of the identifications that were attempted.
I think
So that the magistrate will know that 10 people, 2 people said yes, 2 people said not sure, 3 people said I don't think so. All of that's got to be laid out in the affidavit for a search warrant every time that happens?
I don't think that I need to say that here because I think what did occur was far more egregious than simply leaving out mentions.
But the next case will be what Justice Cordy said. That's what I'm saying, a slippery slope. And you're trying to get a search warrant written quickly. And if all this information from every aspect of the investigation has to be included, it's going to be put an extreme burden, it would seem to me, on the police.
With all due respect, this...
Extreme burden where probable cause still exists. So you're not talking about there not being probable cause. You're just saying, well, but it could be done better.
All that the affiant needed to do in this case was to reveal when he asserted to the magistrate that Regalado had a chance encounter with an individual who was later identified
And the
as a
judge
defendant,
said that would have made no difference.
That he then went to the station, attempted to make an identification, and was unable to do so. And all he had to do was have one more paragraph describing the failures to identify by the very same witnesses who he went through in painstaking detail in this case.
And the judge said it would have made no difference, but you say, but we need this extreme remedy, otherwise there will be no deterrence to police misconduct.
I don't see this as an extreme remedy. I see this as the only remedy for intentional police misconduct, which I think there is evidence was present here.
But that's part I don't get. You say it's the only remedy. If Judge Kottmeyer had said, if I had known what was omitted, I would have suppressed. I would have suppressed. So I'm going to suppress. Isn't that a remedy?
There's always the Frank's remedy.
But what I'm saying, and what I think this court has said on numerous prior occasions, is that isn't enough, because if the suppression is only required when there is when the issue of either the misstatement or the omission is determinative of probable cause, then there will be all sorts of other omissions and deceptions that go unpunished. We essentially are saying, as long as in the final analysis the court determines that there was probable cause, we don't care if the search warrant affiants lie, and we don't care if they deliberately
we didn't say lie.
Okay, lie, different. Isn't that different?
I don't think it is.
On the
and I don't
range of
think
egregious misconduct, omitting information is the same as committing perjury? Is that what you're saying?
Yes, I'm saying in this context that they are the same. They should be treated the same, and they have been treated the same in the past by this court.
They have? Where?
In the cases that have acknowledged that an omission gives rise to the same analysis and remedy as a deliberate misstatement as a misstatement under Frank's. I think there are numerous both federal and state cases.
But none that impose the remedy you're seeking here.
No, No, because this court has never before held that Article
has any other
14
court.
requires something other than this probable cause assessment. If I could just very briefly note that there is another issue in this case, which is the Melendez-Diaz error. And
Know that, and
as
your
I-
time is way up.
Very well.
And
I
we-
would simply note that it was a preserved error, and that therefore the defendant is entitled to reversal on that basis.
Thank you, Ms. Kavanaugh.
Good
Ms.
morning, Your
Grant,
Honors.
good
My name
morning.
is Marguerite Grant. I'm an Assistant District Attorney in Middlesex County, and with me is David Sollett, also an Assistant District Attorney who was the trial prosecutor. This is not the case to reach the issue left open in $992
Why not? It seems pretty egregious. I mean, it seems so pointed.
because this court does not have a record of the complete photo arrays, and it's clear from this record that it's what this court has
So
is
why
a
don't we just
partial.
why don't we just send it back for a hearing? I mean, I understand why Judge Kottmeyer didn't do that, because there was nothing that said she should. But if you're saying that an evidentiary hearing would establish that it's not egregious and it wasn't deliberately deceptive and so on and so forth,
Well, the requirement for a Franks hearing
Right.
is for defense counsel to file an affidavit under Rule 13, setting for, and Franks is very specific and very
Right, no, I
deliberate about the
understand that.
showing that's required.
No, I understand that.
Here, there were 3 photo arrays, but what we have in the record is only the first part of the first photo array. This first photo array was shown to 3 different witnesses. And so it appears, because there are 3 different forms that were filled out when the witnesses viewed those photo arrays, it looks like all 3 photo arrays. And I think Justice Kottmeyer was misled by that. And so it's ironic to have a case where...
I know, I understand that your claim is that you might not, that the affidavit didn't exist or wasn't sufficient, but couldn't the Commonwealth have put in the other photo arrays?
The Commonwealth could have put in the other photo arrays.
Well, then we
But
would...
it is the defendant's burden.
No,
in
I
order to be
I
entitled
understand
to a
that.
Franks
I
hearing.
understand that. But if you're saying they're not deceptive because of some other evidence that wasn't put in,
Even from the 4 corners of the search warrant, it is clear that there were 3 different photo arrays. The first photo array contained this defendant's picture and 21 other photographs of people not relevant to the case. And the 3 witnesses did not pick the defendant out from that photo array, and that was the information that was omitted from the warrant.
Right.
The second photo array contained Perez's photo, and all 3 witnesses did pick out that
Well,
photo.
didn't it also contain the defendant?
The third photo array contained both.
But
The
the
second
second
photo
didn't.
array only contained Perez. And so where the confusion is arising is the application for direct appellate review represented to this court that there was a photo array containing both defendant and Perez, and that from that same photo array, Romero Regalado had picked out Perez and failed to pick out from the defendant. That's not the state of the record. It's clear from the search warrant.
Okay, so then I'm confused. So
But-
this
but-
Regalado who basically came to the station say, I just saw the guy, he was then shown a photo array. The defendant's picture was not in it?
The defendant's picture was in that
Right,
photo.
and he didn't pick it out.
He didn't pick him
He
out.
said, I just saw him, here's the photo array, oh, he's not there.
Correct.
And that, he's not there was not put in the search warrant, but
Correct.
I just saw him was.
Correct. Where the confusion is arising is Justice Kottmeyer seems to have been assuming, as the application for direct appellate review baldly claimed, that there was a single photo array that contained both people.
I understand the
think it
point. I'm
makes-
not sure what the relevance is, because we're really focused on that last piece, aren't we? Or am I
well,
misunderstanding?
if you put all 3 in, why is that going to make your case any better?
Yeah.
It goes back to the Rule 13 issue and the issue in Carrivo as to the entitlement to a Franks hearing in the first place.
She got a Franks hearing.
She held a hearing. on
Well, I would say it's not a Franks hearing, it's a Duzanis hearing, but that's fine. I don't, because
Okay.
a Franks hearing implies the judge has made a finding based on the preliminary showing that there is a misconduct or
right.
misrepresentation. This is something that I take very seriously when there's been an accusation of misconduct against a police officer who's written a 9-page single-spaced affidavit in response to somebody shooting up Marlboro, appearing before a magistrate. He probably appears before all the time, and to be accused of having made a misrepresentation by
Well,
this
you'll have to
omission.
agree that the officer, and I'm not suggesting misconduct, I'm saying the officer made a conscious decision to include some of the information and not to include the information that would suggest that the defendant was not the person. I mean, there was a conscious decision, clearly.
I don't know that it's, well.
Maybe that's okay, but I'm saying you can't say it was somehow
It's
unconscious.
U.S. v. Atkins, I think it is a federal case that I cited, that's been cited by our district court in Massachusetts a few times, talks about the fact that in some cognitive sense, any omission of information.
No, we're
known
not
to a
going that
person-
far.
Sorry?
We're not going that far, but I mean, you're focusing on identification of Perez, of the defendant,
Correct.
right? And he's got clearly two sources. Bang, bang. It's not, 4 hours later or something unrelated. It's this person identifies him, this person comes to the police station, and this person doesn't pick him out from any photo array, 1, 2, or 3. Correct?
But this person had described him in terms of his height as being the most distinctive feature. This person had seen him in person, standing in front of this address. It was confirmed by police who went there soon
No,
after,
I'm not-
and that's why Justice Kottmeyer says it didn't make a difference.
No, well, you're skipping. That's not the point of whether it made a difference or not. The question is whether there was I think Justice Cordy's term was a conscious omission.
Well,
And you got on to,
in
well,
some
no.
sense, but see, in some sense, every omission.
No, but
is
it's not in
conscious.
some sense. Because sometimes there are two completely unrelated pieces. Yes, afterwards, with 20/20 hindsight, you could see that, the car was maroon. This is a very, very narrow.
I don't know that at the moment Detective Manning was writing the affidavit, he consciously remembered.
You don't
that-
know, but I'm suggesting to you that a reasonable inference is that he did consciously omit it.
I would say there's also an equally reasonable inference that under the stress of writing this
That's
9-page
possible.
affidavit, he had.
I understand your advocacy, but I'm suggesting it's a perfectly reasonable inference that not only did he do it knowingly, he did it intentionally.
Justice Kottmeyer didn't make that.
I
finding.
know she didn't have to,
Right, because under Corrivo, which she followed, the evidence was
because we
immaterial.
didn't have to decide the issue. You started off saying, this is not the case to decide the issue left out of 992. And I'm suggesting that your premise, I understand from an advocacy point of view, Ms. Glamp, but you're not exactly helping your case from my point of view by taking the position that it's just, the brain works in funny kinds of ways, and whenever you've got an omission, you can argue that omissions shouldn't be the same as affirmative misrepresentations, but not because the brain works in different kinds of ways. People make affirmative representations honestly believing that that's the case. It turns out they're absolutely factually dead wrong.
But I think on the facts of this case, where the omission was of this particular detail in the context of what Justice Kottmeyer called an exhaustive investigation, and where she didn't make a finding because Corrivo said she didn't need to reach
Correct.
that because it was not material, I think given all of that, it is not an appropriate vehicle for the court to reach the issue raised by $992.
I followed you all the way to the last sentence. That is to say, we could decide any of the following. We could decide that we are going to decide the issue, but it's prospective only, end of case. We could decide that we're going to reach the issue and rule in essentially to say we don't agree with the defendant's analysis, end of case, or we could decide we're going to reach the issue and decide as the defendant would like us to decide and send it back again.
My point, I guess, is that if the court were seeking to reach the $992 issue and to make new law about omissions being tantamount to deliberate misrepresentations, then it would be extremely ironic for this court to pick this as a vehicle to do it, where I'm informing the court that the state of the evidence of the photo arrays is itself containing omissions that have misled the trial judge, and I wouldn't want them to mislead the court.
I don't see how they've misled, because what you told me, and maybe I'm misunderstanding you, is the first one had pictures of the defendant.
Correct.
And the witness did not pick him out.
Correct.
The second one had no witnesses of the defendant, and the witness did not pick him out.
Correct.
Correct. And the third one had a picture of the defendant and Perez, and the defendant did not pick him out.
Well, it was the
I mean, the witness.
downstairs neighbors.
The witness.
The third photo array was only shown to the camera, and to the neighbors, and they both did pick him up. They did pick him out.
As neighbors,
As living there.
as living
And
next door.
as neighbors whose
Not as
surveillance...
involved in the crime.
As neighbors whose surveillance camera had caught the defendant fleeing.
No, I thought we were talking
gunshots.
about the witness. I just trying to figure out where I might be misled. What might I be misled? As to what might I be misled? You said that...
Because Justice Kottmeyer's findings said that this evidence was, should have been included, and it was particularly, I can't remember what adjective she used, particularly, she didn't say disturbing, but
Problematic.
problematic that it was omitted because of the fact that there's information had been included about picking out Perez. She seems to be assuming in there that it was the same photo array. And so,
But everything that you've told me about the 3 photo arrays with respect to the witness, not the neighbors, the witness never picked out the defendant in any photo array.
correct.
So what difference does it make if it's 1 or 3? In fact, if anything, if there were 3 and the witness never picked out the defendant, might be even stronger.
Because it's important that the court understand that the premise on which Justice Kottmeyer's particularly problematic sentence is based is possibly...
Fortunately, we have natural light.
A little.
In any event, I'd like to talk about Melendez-Diaz
Yeah,
briefly.
if I could, before we leave this point, do you agree, let's put aside the facts of this case, okay? Do you agree that if an affiant does omit important information, which may be critical to evaluating probable cause, and does so intentionally, that can be the basis for a Franks hearing?
Yes. I thought about that a lot. The case that I could come up with on the facts that's closest to that is Burke v. Town of Walpole. And I think it would have to, an omission to vitiate probable cause, an omission where there's no misrepresentation. A lot of the cases...
Basically, it turns out that the person affirmatively said, no, it's not, or it was a photo spread, and the officer affirmatively failed to include the fact that the individual said that the person who stabbed me is not here. It's none of these people. That was excluded from the application for probable cause. There was a very weak ID that's in the application. Do you agree that that is the proper ground for a Franks hearing, and that if the judge were to find that if I had known about that photo spread, I would not have found probable cause, that's proper to suppress?
On those facts, as you state them, as I understand it, but it needs to be a pretty extreme omission for there to be grounds for a Franks hearing, because ordinarily it would be a set of facts like Carrivo or even Conlon.
Okay, but you agree that a willful omission may be the basis for a Franks hearing?
If it's of a fact that's so key that it would vitiate probable cause, as in Burke v. Town of Walpole. But a lot of the time in real life, that kind of a fact scenario would result in a no pros or some other procedure.
One would hope that there would be no perjury and no misrepresentation, but the world doesn't always work as well as we'd like. Now, do you also agree that if there were that kind of willful omission, that it would arguably be analogous to an obstruction of justice, or maybe be an obstruction of justice, if it were to lead to a wrongful prosecution of an individual?
I can imagine a set of facts where there could be an obstruction of justice based on an omission, but as I said, it's getting into more and more far-fetched hypotheticals.
I'm speaking theoretically. I mean,
Okay.
because I think we all agree that that if we were to reverse, we'd have to remand for factual findings. So we're in the realm of theory here.
Right.
Now, I guess the next question is, if you agree that there can be a Franks hearing for an omission, and that a willful omission, if egregious, may rise to the level of an obstruction of justice, should we treat that different from a perjury? Which is basically what Ms. Kavanaugh is contending, that perjury is analogous to willful omission, that perjury should result in per se exclusion.
And my point is that most of the cases I found that the omission was willful involved a concomitant misrepresentation.
Right.
And-
I think to my knowledge, all of them do. And I guess the question is there a meaningful distinction then between a perjury and an obstruction of justice through omission?
I think we're just getting into such a realm of I think one of the distinctions is the fact that if the issue is an omission alone, that sort of presumes a situation where a police officer, there's only one person involved in handling the issue. In real life, it'd be an assistant DA and a supervising, lieutenant and all kinds of checks on the individual person. And so it becomes really in the realm of sort of a law school hypothetical to try to come up with a scenario where that is, and I guess Burke is the thing that I can find that's closest to it factually, but again, the null pros happened.
Well, I mean, there are wrongful convictions and wrongful conviction lawsuits. The Supreme
Right.
Court recently, I guess today, dismissed as moot a case which was viewed to be a wrongful prosecution. Are you not able then to say that in theory that there is no situation? Well, I mean, I guess
That's back to my, as much as I hesitate to say it, to my Rule 13 argument. It's very hard to make these decisions in theory.
okay, but it's one thing to say this is not a perjury case. No case has gone that way for a perjury case. Therefore, we shouldn't address it here. I understand that,
Right.
but that would require us to say that a theoretical obstruction of justice should be treated different from a perjury case, because we can't say, unless we make that finding that obstruction of justice is different from perjury, then we really can't say that this case should not be
I
addressed.
think perjury is almost always going to be more willful than obstruction of justice in this sense. I do want to just point out briefly that the Melendez-Diaz...
Oh, excuse me, could I ask one question?
Of
on the
course.
subject? I'm sorry. Ms. Grant, what is your position on whether we should adopt a type of Mayfield-Odell standard that false and deceptive evidence was included in the affidavit knowingly and for the purpose of obtaining the search warrant, and that it influenced the decision to issue the warrant?
I cited to several grand jury cases in my brief as CF sites, and I think that is a helpful analogy. But again, on the facts here...
No. I assume, at least for the purposes of this question, that not for this case, but for going into the future. What do you think of that as a standard?
I think that it is a helpful standard, but again, I come back to the fact that grand jury and search warrants aren't necessarily completely analogous because of the
sanction
stress
is
and
different,
pressure, and the sanction, but the stress and pressure that a detective is working under in drafting a search warrant as compared to the leisure that assistant DAs have in presenting evidence to a grand jury.
Well, when a police officer is testifying, it's the police officer's testimony, and he or she may be under stress and pressure.
Right.
Testifying to grand jury, but
But,
okay.
but here, the detective compiled the photo array forms at the time, fully understanding that they'd be turned over to the defense. So I don't think that we can say that this is...
I said apart from this case. Okay.
Okay.
Thank you.
As far as Melendez-Diaz,
I think your time is up. We can just rest on the
thank you,
brief.
Your Honor.